Good afternoon, ladies and gentlemen, and welcome to the KwaZulu Natal Centre's webinar on Engineering and Patent Law, the symbiotic pair for sustainable innovation. Before we start, a few webinar considerations. Attendees are reminded to ensure the volume is turned up on their device. Ensure you have a stable internet connection. This will ensure the streaming and audio will run smoothly. Attendees can ask questions via the questions panel located within the GoToWebinar control panel. And by default, the control panel is located on the right-hand side of your screen. The chat function is reserved for webinar organizers and panelists to communicate with attendees. Attendees will not be able to chat with each other, however, are encouraged to ask questions. A recording of this webinar will be made available on the SAIEE YouTube channel, SAIEE TV, under the KZN Centre playlist. This channel is updated regularly, so ensure you check back as often as possible for new uploads. And please click on the link that is currently in the chat box to subscribe to the SAIEE TV channel. It's free. A certificate of attendance will be issued a few weeks after this webinar once we have received the CPD validation number from EXA. I'd like to introduce you now to our host for this afternoon, Mr. Shepherd NKOSI. He holds a Bachelor of Technology degree in Electrical Engineering, a post-degree with USQ, University of Southern Queensland, Australia, a post-degree in Project Management with the University of Stellenbosch, and he's currently completing his Master's degree, MSc Electrical Engineering with UKZN. He is the Chairman of the SAIEE KZN Centre, and he served as Vice President of the Durban University of Technology Advisory Board, and he's professionally registered with EXA. Over to you, Shepherd.
Mrs. Afrobus, and a warm welcome to one and all. It is a great pleasure to have you connected this afternoon as one of our guest members or invitees, sorry. And we all look forward to the theme for this afternoon, and it's quite interesting. We have a doctor and an advocate in the room, and we are honored this afternoon to have you, Dr. ERNEST BHERO. And as we all can see, he is a
Apologies, Shepherd, we've lost your audio. Shepherd? Ladies and gentlemen, sorry, Shepherd, please continue. We didn't hear you. Can you just please repeat?
Oh, apologies. Can you hear me now?
Yes, we can. Thank you.
Okay. No, apologies. I was saying a warm welcome to everyone who's connected this afternoon. And thank you for putting this time aside and making sure that you don't miss on this opportunity. We have our guest speaker, Dr. ERNEST BHERO. And what I was indicating is that we are honored as engineers and members, technical members this afternoon to have Dr. ERNEST BHERO as our guest speaker and presenter this afternoon. He is an advocate and also an engineer at the same time. So he is a senior lecturer at UKZN, and as you can see, Dr. BHERO is an electronic engineer by training and a registered professional engineer with EXA. He is also a senior member of SAIEE. He holds 4 degrees, 3 in engineering, and that includes a PhD and a law degree. He is also an admitted advocate of the High Court for South Africa and a member of the NBCSA, which is the National Bar Council of South Africa. And as you are aware, Dr. BHERO will be coming with a theme this afternoon, or sharing a theme with us this afternoon. His theme for this afternoon is engineering and patent law, the symbiotic pair for sustainable innovation. We look forward to this very interesting theme, and I would like to hand over to you, Dr. BHERO, and please take us through. And as we all know, we are more than welcome to share our question at when he's done with the presentation. But for now, let's give you the platform, Dr. BHERO. Over to you. Thank you.
Thank you, Chair, and thank you to all the attendees. I'm very much honored to present to you and share with you my ideas, and we can then debate, upon those ideas, as the case might be. Just give me a minute, and then I can swap my screen so that you can actually see my full screen in a better way. All right, once again, thank you, Chair. The topic that I'm going to be talking about, or the title of my presentation, is Engineering and Patent Law, and here it's a symbiotic pair for sustainable innovation. That's the proposition that that we are putting on the table, and we will try to support that proposition. Now,
Dr.
before
BHERO,
yes,
my apologies, sir. Your control panel for the GoToWebinar is covering your slide. If you can just minimize that for us, please.
All right. Oh, sorry. Thank you. Well, my mouse is not going well. Just excuse me. I'm not seeing my mouse here. Okay.
I think it looks better on my side.
Is it better on your side now?
It's not in presentation
mode. Yeah.
Okay.
Just swap your display settings. But the control panel is still over the slides, Dr. BHERO. There we go. Perfect. Thank you.
Is it okay now?
Yes, please continue.
Okay. Okay. I don't know what was happening here. Technology, sometimes it fights against us, but we will always win at the end of the day. So I just said, the proposition that we want to put on the table is that, when engineering and patent law work together, they form a unit which sustains innovation. Now, before we can dive deep into the presentation, there's just a few quotes that I just want to share with the audience here. And these quotes are derived, one from Sadhguru, and one of the things that he says is that, people must identify more with what they do not know than what they know. And his argument is that, what we do not know is quite unlimited. So if you identify with what you don't know, you are identifying yourself with unlimited possibilities. And I found that to be quite empowering, and we might make reference to some of these in due course. And then the other comment that I just want to share with colleagues here present is from Neil deGrasse. He's a cosmologist or theoretical physicist. He once said a certain statement that caught my eye, and he says that one may know about a subject to believe that one is right, but not knowing enough about the subject to know that one is wrong. What a caution that he was giving us there. And then the last quote, I quote my current president of SAIEE, when he came to UKZN and addressed us early this year, he made this remark. He says, if our schools of engineering and various universities are not commercializing at least one of their projects per year, then something must be wrong. So we will revisit some of these quotes, and see how they dovetail into this presentation. The outline of the presentation, we're going to start by looking at the overview of the world of patents, follow that by looking at the basic structure of patent application, which I believe is one of the important areas, in this presentation. And then we'll look at an example of a patent, a transformer, a patent of 1997. And then we'll also look at another example of a smartphone, Apple Protector, and that is a 2015 patent. Thereafter, we will look at an example on patent infringement, and that would allow us to give a word of caution after analyzing just a few cases there, just briefly. And then we will look at how sustainable innovation can be maintained, and we then conclude by making some recommendations. So let's start by asking, what is a patent and what is the rationale behind patent protection? Now, according to WIPO, a patent is a legal document granting its holder exclusive right to control the use of an invention as defined in the patent's claims. And I've underlined the phrase as defined in the patent's claims, because that's very, very important. And then the definition continues and says, within a limited geographical area and time, by stopping others from, among other things, making, using, selling the invention without, of course, the authorization of the inventor, as the case might be. But the second question still lingers. What is the rationale behind patent protection? Now, the underlying idea behind patent protection is that we need our industrial processes to be improved, all the time. So in a quid pro kind of arrangement, the patent or patenting system came into being. And the idea behind this is that the society simply tells an inventor that, please disclose your invention in full to the society. And the society, what it will do in return, it will provide you with limited protection, or it will give you protection for a limited time. I think that's the better way to, to express that. So that during that time of protection, the inventor can reap the fruits and the benefits of the invention. But of course, when that time lapses, the subject matter of that invention becomes part of public knowledge. Anyone can actually use or exploit that particular patent. Now, we must then ask, how many types of patents are there? Essentially, there are two main types. There is what we simply call patents, but some might use terms like pure patent, although that's not an official description. And then the other one is the so-called the design patent. And what is the difference here? With the patents, they protect the underlying idea of an invention. Patents protect an underlying idea of an invention. And usually the protection period for a patent is 20 years to be exact. On the other hand, design patents generally protect what is called aesthetic and functional aspects of invention. And in South Africa, the design patents are protected for up to 10 years. And in fact, in South Africa, we have two separate acts, one that deals with patents, and then the other one that deals with design patents. But in today's discussion, our focus is mostly on the patent. Now, when we give a definition of a patent, we use the phrase geographical area. And this speaks to what we call the territorial nature of patents. And what do we mean by this? This means that patents have an effect only in the countries where they've been applied for and granted. Also, following this statement, it means each country has the sovereign right to grant or to refuse to grant a patent. But as we all know, inventions often have an international scope. And in order to address the international question, a variety of treaties over the years have been concluded, the object being to assist, the applicants. And I will just give a few examples. For example, the so-called the Paris Convention, the so-called, PCT, the so-called TRIPS, the so-called ARIPO, EPC, or HAPI, and many others. Having talked about the patents, the question that we must answer is what is the effect and perhaps the term of patent protection? Now, I must emphasize this point that, as highlighted earlier on, patents are territorial in nature. And what this also means is that each country has its own laws that govern, the patenting system. Although to a large extent, you might have a lot of commonality and some standard is actually followed by most of the countries, but you do find some variations. And here I've used South African Patent Act, what it says when it comes to the effects of a patent, and of course the term of protection, which I have already highlighted and I'll add to you. And in terms of the South African Act, it says the effect of a patent shall be to grant the patentee in the Republic, that is South Africa, and of course subject to the provisions of the Patent Act, and for the duration of the patent, the right to exclude other persons from making, from using, exercising, disposing, or offering to dispose or importing the invention. And the idea being that so that he or she, the inventor, shall have and enjoy the whole profit and advantage accruing by reason of the invention. And as I said before, the protection period is usually 20 years for a patent. Now, the next question that we must then ask is, what are the requirements for an invention or for an invention to be patentable? I think, let me put it that way. And this, of course, I will continue to be guided by the South African Patent Act, but you will find what the South African Patent Act says is quite common with what we find in other countries, as well. So in terms of Section 25 of the Patent Act 57 of 1978, it says a patent may be granted for any new invention. And the phrase new invention is highlighted here, which involves an inventive step and which is capable of being used or applied in trade or industry or agriculture. In other words, if one comes up with an invention, but that invention is not capable of being applied in industry, trade, or agriculture, that invention cannot be patented in South Africa. And also, if one comes up with an invention and it is then found that that invention lacks what we call an inventive state, then once again, that invention is likely to fail, to be patented. But more comments in this regard later on. And then the patent also goes on to say, an invention shall be deemed to be new if it does not form part of the state of the art immediately before the priority date of any claim to that invention. Allow me to remind you once again here that when we were defining patents and protection associated with it earlier on, we once again referred to the claims, what the claims of a patent say. The claim part of a patent is extremely important, and we shall expand on this point shortly. And then in terms of the South African Patent Act, it also goes on to say, an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art. And I think I just need to explain two things here. The first one is reference to the art or state of the art and the person skilled in the art. Now, the state of the art, what they mean by this is to say, for instance, if we are in a field of manufacturing transformers, designing and manufacturing transformers, someone who has been working well in that, in that area will probably know all available, all known techniques on how to build different types of transformers, as the case might be. Now, all that information, which you can find in other countries, in publications, etc., which talk about how to make different types of transformers, will be classified as part of the state of the art. So if something is to be new, it means that something or that invention must not form part of the state of the art. But then the Act goes on to tell us further to say, look, if somebody has come up with something which is outside the state of the art, that means there has been the so-called an inventive state. How do we come to know that this particular invention has an inventive step? And this is where the Act goes on to give a direction and tells us that if that invention would not have been obvious to a person who is skilled in a particular art, and I've just given an example of transformers, but you can think of many other related fields as the case might be. And I must also say at this point that where most of the battles in courts about patents infringement, etc., they usually surround some of these, concepts, because some might claim that, look, your patent which you are saying is an inventive step, we think there's no inventive step, and we've got our expert here who can be a witness, and we can show to the court that, there's no inventive step. And for sure, if you can show that, that particular patent will be revoked, by the court to say, this patent we are revoking, as it were. So much of the litigation, as it were, really surrounds some of these critical terms that we find under patentability. But now let's move to the aspect of the basic structure of a patent. And perhaps this slide talks to the core of our discussion, and perhaps everything else flows from this. Now, on the basic structure of a patent, now we can look at it at surface level and simply say, look, there is what is called a request, which must be made by the applicant. But when an applicant makes this request, the applicant is explicitly asking to be protected. And usually the documents that request, it must be the applicant who signs or the representative of that applicant will sign, those documents. But of course, the documents must also contain what is called an abstract. And the abstract, in short, it's just a limited summary of the claims of that particular patent. But of course, from our various backgrounds in research, etc., we might, of course, define abstract in a slightly different way, as it were. But when it comes to patents, we are mostly concerned with what is being said in the claims, and we try to summarize that. Now, I have highlighted the steps, specifications, and claims, because this is really where I think I have more to say. So what goes on? The next one is specifications or description. Now, remember the quid pro quo that I highlighted earlier on. And here, if you recall, under the quid pro quo, we said the inventor is asked to disclose everything about the invention. And in return, the inventor will then be protected by, by the society. So in your specification, when one is drafting a patent or so, one is expected to give the full disclosure of how that particular patent or objects of that patent can be constructed. And in fact, in some jurisdictions, they actually say what you described in your specifications must be, the best or the favored, embodiment of the patent, as it were. Now, what this must tell us, though, is that it means if a person was an expert or maybe a person experienced in a particular art, and I just gave an example of a person who is experienced in transformer constructions, as the case might be. Now, if a new patent comes up and that person with his skill in the field of transformer construction can pick up a new patent and go to the specifications and study the specifications in detail. At the end of that study, that person who is skilled in the art of construction of transformers should be able to follow the steps described there and be able to construct the new transformer or the transformer resulting from the new invention, as the case might be. So in other words, it means if you pick up a patent, the patent will tell you how to construct the favored embodiments or objects of that particular patent. And what this also means is that if, for instance, I discover a patent which has lapsed or which has completed its 20 years, but I still see that its products are still being used today and they are still wanted, I can form my company, study the patent in greater detail, put up manufacturing, setup to be able to manufacture the objects of that particular patent. And then I manufacture them, then I also start selling because the patent has actually lapsed. So the patent specification allows a person skilled in the art to be able to actually construct the subject of a patent or a favored embodiment of a patent. So that's how important it is, and that's why this information is so important on patents. But then the most important part of a patent, it is the claims, and I've even shaded it in gold because it is really the golden part of a patent. Under the claims, the inventor defines the scope of exclusive patent protection in terms of the technical features of the invention. It means the inventor will say, look, in the field of making transformers, this is what the current state of the art is. This is what is there. But now what I have done, I have moved this additional step beyond the state of the art. And I want protection for this additional step that I have taken, and all that will be captured under your claims. Normally, claims may have statements ranging from, or claims ranging from 10 to 20. Usually, there are not so many paragraphs there, just a few paragraphs, 10 to 20, for example, under the what? Under the claims. So what I must then add at this point is that if, for instance, I'm a person who is experienced in the arts, and I will still continue to use the example of a transformer, and I'm told that a new invention on transformer has come up, there's a patent there. Then what do? I go and, of course, get hold of the patent. I look at the specifications, where, of course, the patentee is expected to also describe briefly the state of the art and then how to carry out his own invention. But more importantly, I will then look at the claims section, because the claims section will then tell me that, this particular person is asking for protection, on this and that aspect. But having read the patent and being skilled in the art, it means I can actually come up with a slight variation of that patent, but making sure that it does not infringe the claims or what is claimed by the person who is actually published or applied for that patent. It means by carefully studying and detailedly studying specifications and claims, a person skilled in the art may actually come up with certain variations and even be able to lodge his or her own what? Her own patents. That's how important, these areas are. And I have deliberately taken time on this particular slide because of the importance that I actually attribute to it. And then the last aspect is really the drawings. And the drawings, for technical colleagues who are here, the drawings help us in clarifying a particular design, a particular invention, as the case might be. So there's no need to say anything more. Maybe at this juncture, it might be right to pick some few examples. And the first example that we are going to pick is a transformer patent. And this transformer patent, as you can see, colleagues, was actually published in 1998, thereabout, not so far away. And when I think of 1998, and I think majority of us here were already practicing as engineers or perhaps completing university degrees, but we're already using transformers and other things. But it's quite interesting to note that, but this looks like a fairly recent, application for a transformer patent. So there must have been something special or something that this particular inventor thought made an additional step ahead of the state of the art. And of course, the inventor in this particular application is Markov, and the representative is given there. Now, let's just move a little bit. Let me see if there's anything else which is worth mentioning here. We might have to come back when necessary. So the example continues. And what I have simply done here is I've extracted some of the claims from this particular patent. But I just want to emphasize just very few concepts or very few ideas here. And I'm just using these claims to illustrate this. Usually, when one drafts the claims, you usually have the so-called independent claims. It means it's a claim which stands alone and is not dependent on any other claim. And then after that independent claim, you may then have what are called dependent claims. Now, the whole idea is this simple. The independent claim usually picks the core aspect of a design or of a patent. But now the dependent claims, what they go on to do oftentimes is that they then give additional descriptions or additional variations to show you what additional features are actually added on the core. and those then become the so-called dependent claim. If you look, for example, this particular patent that I just showed you, this particular claim 1, it says a transformer comprising a magnetic circuit, at least 2 windings, inlets for power supply, outlets for a load, characterized in that a primary winding consists of 2 sections with an identical number of 10. The sections being connected to each other in a series circuit. So it's like the person is starting with the core. This is the basic transformer, and most people would say no, but that's basic transformer. So you're starting from there, and then you would see then they move, and I've just skipped claim 2 and I've skipped to claim 1. Now under claim 3, for instance, it says a transformer according to claim 1. So when the patentee uses such a term in the claims, what it is telling us is that, if you look at what I said under claim 1, now, based on that, these are the additional variations or modifications, that can be done under the claim 1. So he goes on to make the statements, and we are not concerned really in going into the details of all the claims of this transformer, but just to illustrate independent claim, dependent claim, as the case might be. I also picked up claim number 5, and then you see what it says under claim number 5. It says a transformer according to claims 3, 4, characterized, then it goes on to say this and that. And what this is simply saying is that under claim 5, it's saying what I described to you under claim 3, and what I described to you under claim 4. Now, these are the additional variations, from that description. And I think my last that I give under this is claim number 10. This particular patent had only 10 claims. So if, for instance, you were an expert in the field of transformer construction, after studying this patent, you can actually be able to construct, your own patent, your own transformer based on this particular patent. Only 10 claims. No. So in this particular one, it also goes on to say a transformer according to claims 6 up to 9, as the case might be, and then it goes on. So I've left quite a lot of material, on this, but for people interested can look into that. The second example is a smartphone screen protector. But the interesting thing about this particular patent is that it is a 2015 application. So when we look at 2015 application, you say to yourself, but look, 2015, we already were using screen protectors. But of course, this is a different type of a screen protector, which is being patented here. And also the other thing that I want to highlight, to the audience is that the inventor here is Tyson B, and then there is also Stephen, there is Emery, as the case might be. And interestingly, the assignee, that is the person who has been given the right to exploit that patent, of course, paying fee for it, is actually Apple and this other company there. In other words, this tells us that we engineers, we technical people and others can come up with patents. We can then sell this, or we can then assign this or give these patents to big firms, as long as these patents actually help them to get an edge over their competitors. This can actually be done. I shall not dwell further or in detail on this particular example, because the illustration that I shared with you using the transformer applies, here as well. And this is the diagram, or some of the diagrams that you find there. And then you also have the claims there, claim 1. And then you can also see here, I have claims 5 and 13. And you can see how they make reference to earlier claims. This allows one to fully understand and study patents. Now, having said this, I'm of the view that it might be time to just look at a few case law and just illustrate really what has been happening out there. Now, on the case law, or the laws that, the cases that have come before the courts, one of them was the case between Orica Mining Services and the so-called Elbrook mining products. The case started in the Court of the Commissioner of Patents. And what was happening there is that Orica actually approached the commissioner's court and say, look, Elbrook is actually infringing, and they went on to even identify the claims in their patent that were being infringed. Like in this case, you see they identified claims 1, claim 6, claim 16 rather, claim 17, claim 18, etc. So in the first court of the commissioner dismissed the application of the Orica Mining Services and say, look, Elbrook is not infringing your patent. But then Orica Mining approached the Supreme Court of Appeal, and then the Supreme Court of Appeal then looked at the judgment of the commissioner and looked at all the facts that had been put before the court. And then it made the following judgment. The judgment that it made was that Elbrook was found to be actually infringing the patent of Orica Mining, and they were actually ordered, or rather interdicted or stopped from infringing that particular patent. And in addition, they were also asked to pay the cost of the cost of the suit. Now, what I think I might need to put on the table here is that, look, as I encourage that we should be studying patents more and more and see if we can establish our own companies that can either be using patents that have expired or that can be using patents that are in existence. More importantly, let's study carefully what the claims are saying, so that when we do this work or when we use aspects of the patent, we do not infringe the patents, as it were. It's much better, not to walk blindly. And that's one of the highlights that I wanted to put in here. And on this one, I have just two cases that I'll briefly talk about. Mentela Trading versus Kusile. They are all mining companies. And what actually happened in this particular case is that Mentela Trading actually sued Kusile, saying, look, they are infringing their ventilation passageway, construction. They'd come up with a patent for constructing passageways underground in the mine. But of course, the case also followed the same route like the Orica case. It started from the commissioner, and then Kusile won the case. But when Mentela appealed to the Supreme Court of Appeal, then the Supreme Court of Appeal actually found that Kusile was actually infringing, the patent. But what is interesting to highlight in this particular case and the next one is that the court went on to even ask for an inquiry to be done to determine the amount of damage that Kusile had actually done to Mentela Trading. The damage in the sense that they manufactured and possibly sold or distributed products that were a subject of the patent of Mentela. So that inquiry would then determine the kind of damage. And that's why you see people paying billions or millions of dollars, as it were. And then the last case law that I would just want to briefly talk about is Clipsal versus Trust Electrical. And I think colleagues who are present, who are from electrical, you can all see what's showing there. It's a simple cover for a 3-pin plug, as it were. A cover for a 3-pin plug. But what actually happened in this case is that there was a US patent, and then the US patent, they had their representatives in South Africa, Trust Electrical, the South African, or rather clipped out the South African branch. So those were actually importing, and the manufacturing the US patented product. But Trust Electrical went on to construct something closely related to the patented product. But in this particular case, it was not like a pure patent as it were, it was rather a design patent. So in the design patent, they looked at the aesthetic aspects and they looked at the functional aspects of the patent. And once again, the infringer, the Trust Electrical, they lost the case. And then once again, an inquiry was ordered to determine the damage, how many of these had you sold? So how much money, how much royalties were you supposed to have given to, to the owner of the patent? And that's what actually happened here. Now, having said this, I think the next few slides will move very fast because they are more straightforward. The next one is, we answer the question, how can sustainable innovation be maintained? And in this case, I would choose to start by just highlighting the worldwide IP trends. And the diagram that we are looking at is for patents that had an international footprint that were lodged between 1884 and 1999. If you look at the graph, you would see that America was leading, United States was leading, 1,576 patents with worldwide footprint. And you would see on the list of the countries, United Kingdom, Canada, etc. But I want you to take note of the position of China. China within that period had only 77 patents with international footprint. And it was number 8, in this case. And if you divide 77 into 1.576, it means US was 20 times, or was producing patents 20 times more than China. But come to the period 2000 to 2020, look at the map, how things have changed. America is still leading, but China has actually superseded, has jumped all the other countries, and it is now number 2. And the summary that we see is that China is now number 2 with 3,640 patents. Now, when compared to US, it means it was now 1.9 times, or producing patents 1.9 times less than US. Initially, US was 20 times more. And in China, if we look at these figures, it means they were now submitting patent applications every other 2 days compared to about 1 patent per day for USA. So and you can see the developments that have taken place in China, and you can link this to the patenting world. Certainly, there is wealth to be made out of patents. And then, of course, the design patents, but I'm just going to skip the analysis of this because it's not really core of the presentation, but for completeness' sake, it is there. But you can almost see the same trend, as it were. So the next question that we try to answer under the question how sustainable innovation may be maintained is patents and economic growth. And it is easy to simply summarize what we have just seen in the last 4 slides. We see that countries like China that increased their patent output registered the fastest economic growth. For China, for example, it recorded within the year 1884 to 1999, well, that should have been to 2020, I think, they recorded a total of 38,266 patents. But of that figure, 30,063 were recorded in the period 2000 to 2020. And this means that about 79% of the recorded patents in in China, were produced in the last decade. And no wonder why we see China is one of the fastest growing economies and possibly about to supersede, America. But now let's just ask what is happening in our own backyard. What I'm showing here is a table that was extracted from the reports from the Department of Higher Education on productivity. And in particular, this particular table was actually showing the journal articles produced, or productivity comparing different fields, or different subject areas as the case might be. And what I want to draw your attention to is look at the role on engineering and the built environment. And if you see the number of units there, that's about 1,216 for 2017. And then in 2018, that's about 1,390. And then in 2019, it was about 1,730 and 39. But on the front of the patents that we produce, it's very few patents that we produce. Now, if these are the publications that we are doing in journals, and if we were to say, look, let's just 10% of the work that we do as academics and as engineers, we divert the attention to patents generation, patents exploitations, and patents creating. It then means that it is likely then that industries will also be formed, because as we make more patents, or as we commercialize them, more importantly, the more we can generate, or the more we can create industries, locally. But if we are not creating industry, but it can also mean that we can license our patents to international companies, and that can also gain our respective countries, the required foreign currency as the case might be. Just 10%, of what we are currently producing, convert that into patents. And out of what the 10% we convert into patents, let's just take 10% of that as well and produce and commercialize that 10%. We can really realize that it might be possible to actually come up with 150 commercial products. Well, maybe not as high as that, but the estimation takes us closer to that. But this is where we ask ourselves, why are we not doing this? What is happening, in our researches, in our universities, as other engineers working and other technical people working in the industry? Why are we not moving in the direction of the patent? Allow me to move and just share with you one interesting presentation that was held on the 28th of June, which was also, I think, run by SAIEE. And that webinar was on greenhouse-free solutions for sustainable power. That was the webinar. And there was a reference in that webinar to world's first SF6-free switch gear. I think most electrical engineers would know that the SF6, gases or chemicals, if you may, are used in our switch gears one way or the other, and this has an adverse impact when released into the atmosphere, has adverse impact on our environment and, of course, the climate. And also in that webinar, there was a reference to vacuum interrupter, clean air technologies, as it were. And the question that we ask ourselves is that our universities, our industries, but particularly universities, do they not have equipment that can allow them to do researches in some of these areas? Why I think like this is because if this webinar, what it was sharing with us, is true, which I believe to be true, it means there is a patent out there which now tells us how the vacuum technology and other clean air technologies are being used to come up with better, breakers, as the case might be. Now, our universities if we do have the relevant equipment, can't we also start studying those patterns and seeing how we can develop our own skills and perhaps our own variants of those patterns? And I ask this question, and from what I know is that here at UKZN, for example, there is a lab with a cryo refrigerator, vacuum furnace, among other things. And I ask here, wouldn't it be possible to start work in these new technology areas, guided, of course, by the published patents? Because what we need to do is just go and get hold of that patent, whatever few dollars or rands they ask us to pay, if needs be, we buy it, we study it. The specifications will tell us how they are doing it, and their claims will tell us what they are protecting. And we start training our people, our postgrads, and they start working on that. But anyway, those questions we can ask, but there is always a silver lining when you look elsewhere. And what I'm sharing with you, colleagues, here was published in the Patent Journal in South Africa. I think it was in 2020 and 2021. What I want you to take note of here is that we see our own utility there, Eskom Holdings, and a colleague there, Adigon Peter, possibly the inventor. So the device on the left-hand side there, it's a system and method for fault detection. It means a patent was actually lodged with the South African Patent Office. And on the right-hand side, we also see our utility there, Eskom, and we also see our colleagues there. Peter is there, as it were. Pile is there, as it were. And this is a temperature logging system. So it means the patent was lodged. At least it's a silver lining, under a dark cloud. And colleagues, allow me to conclude by making the following remarks. Wouldn't it be right if all technical people were to be trained in basic patent analysis in addition to technical training? Wouldn't it be right for governments to ensure that appropriate policy changes are made to ensure that it becomes mandatory for all technical people, perhaps more so people from the engineering field, to be trained in patent analysis, as it were? Because this will allow them to start studying more and more patents that are out there, and possibly start adapting some of those patents into commercial products. Because patents tell us how to do things. Patents tell us what is protected and what is not protected. So I ask, wouldn't it be right? And I also lastly ask and say, all other possible actions that can further the training, wouldn't it be right? Maybe I should put it this way. Wouldn't it be right to promote all possible actions that can further the training in patents generation, in patents protection, in patents adoption, in patents commercialization? Shouldn't it be considered very seriously? Our academics in the technical field, in engineering, shouldn't we be taking maybe just 10% of the work that we do, and we then put that work into patents? Can't we train our postgraduate students to study the patents, to create the products of patents, to be able to make and develop the skills to do things? I think from what we have been seeing, we can see that this is doable. And allow me, with the permission of the chairperson, to conclude my presentation at this juncture. And those were really my references. And I thank you very much. And thank you, Chair. I yield back to you.
Thank you so much, Dr. BHERO, for your presentation. I think it is, the audience will agree with me that it was well packed, and the information is really what we are looking for as engineers. And one thing that's quite interesting is that you will agree with me that the technology is revolving. There's so many innovative ideas. And I mean, to your point, you were actually challenging us as engineers to get involved into these discussions and to also understand and own the space, because it is our business, it is our technology, it is us as engineers who come with innovative ideas. And now the question is, how do we protect our work? I think we've got few questions that I see they are noted already. And actually, it was quite interesting to also note during your presentation, Dr. BHERO, that a patent has got 20 years lifespan. But I mean, in that 20-year period of, it was quite interesting to understand the claims and what does that mean to your entire patent. But again, as the technology revolves, it's quite an interesting discussion. I'm sure maybe at a later stage, we'll also like to further unpack this to say, what does that mean? Post 20 years, what does it mean to the owner of the patent? If maybe for some reason I've decided not to do anything, it was quite interesting, those comments that you've shared there with regards, that and some of the challenges that already exist as a result of, the misalignment there. There's 3 or 4 questions already that we've noted here. Maybe let me go straight to the next one while we thinking of some of the questions that we'd like to also jot onto our chat box. Does full disclosure not compromise on the patent to be created? I think you've mentioned there that it is good that sometimes there's full disclosure. There's a question from Gideon. He wants to know if full disclosure does not compromise on the patent to be created, or maybe someone copying the very same solution that you're about to develop. Maybe let's stop here for now and give you an opportunity, Dr. BHERO, to provide an answer if possible. Thank you.
Okay, thank you, Chair. Yes, it's a big question mark, that we have to say, look, I fully disclose my invention. Won't people take advantage, of it? Well, the patent system or the patent world, that's really how it works, because it says, tell us everything in full, and we will in return protect you for this limited period and within this limited geographical area. Now, the limited period, of course, being the 20 years. Now, what that really means is that one has no choice about disclosing the full details of the invention. However, some people sometimes think and say, look, like for instance, Coca-Cola is a good example. They say, look, we are not going to disclose the formula for making our Coke. We're just going to keep it as a trade secret. So it means it's something that they do behind their closed doors, the formulas and whatnot. At the end of the day, they simply give us the product and we drink the Coke. They can protect that secret for as long as it's possible. But now what happens is that the moment someone else stumbles onto that formula and they start making their own Coke, Coke cannot sue that person, anymore. The reason is that, for instance, if I'm speaking from the South African point of view or the law here, the reason is that what is defined as state of the art, that means the information which is already in the DOM, it includes methods or trade secrets that are being used to manufacture products or and the like. They are considered to be part of the state of the art. So the moment someone stumbles into your secret, then you are finished. You can't sue them. But on the other hand, if one discloses in full and one has actually designed one's claims properly, all one has to do is to keep an open eye in the particular jurisdiction where one is protecting one's patent and see if there are no people who are actually making one's own product. The moment you see them, then you go to the courts for help. just like in the examples that I gave you, an inquiry might be ordered by a court to actually go and find out how much did this person use your invention, how much money did they make, and then they will be forced to pay you what is due to you. So that would be my answer to that question. Thank you, Chair.
No, thank you, Dr. BHERO. And there's another one also there. What protection is given to students who design and invent while they are at varsity using the university resources? And what is the general rule when coming to such invention? Will the student get any rights or credit for their work? I know this is now touching into your space, and I'm sure there's some contracts and IP that the students sign, but I think maybe more the interest here from Walter is what if that results to a product that will go out to market?
Okay, thank you, Chair. Yes, that's an interesting question, and what normally happens, maybe I must start it from this angle. When one is applying for a patent, the patent system always insists in saying, look, tell us who is the inventor. So if from that perspective, if a student comes up with an invention, which ultimately becomes a commercial product, as the case might be, when there is an application for a patent, the student must be listed as the inventor. However, in a case where the student is working under a university and under the supervision maybe of another person, usually joint ownership of the patent is normally then negotiated. But in a case where it is not negotiated, what happens is that the inventor will actually assign the patent to to the institution, as the case might be. But here, I must say this, it actually varies from one institution to another. Some institutions do have an IP kind of contract that students sign in before they start working on something. But the truth of the matter is that if that work becomes something big, the student will have to get something, out of it. I think in short, that's what I would say, Chair. Thank you.
Thank you, Dr. BHERO. So yeah, thank you for that response. And it's clear that as engineers, you're also encouraging us to go through our contract. It can be a student, it can also be maybe one of the engineers. You're providing a solution, and it ends up being something that will really be a new product. And I think this response is also applicable to engineers as well, full-time, not only students. There's another question. There are limited companies who can drive their own product from R&D, which that is research and development, to full commercialization. We need to create strong relationships between universities and industries that protect both industry and investors. Some large companies have unfortunately taken advantage of inventors in order to re-engineer products. I think this one is more a comment from Stephen, but maybe as you provide the comment, maybe you can touch on this one, Dr. BHERO. There's another one, interesting presentation. Thank you, Dr. BHERO. I was hoping you will also demystify the difference between registering a patent vis-a-vis intellectual property protection. Can you touch on that, please? I'm not sure if that time will allow you, Dr. BHERO, to touch on this one. It's a comment from Pascal. Maybe high level, if maybe it's possible to do so. Otherwise, I know there's future presentations if it's a discussion that will require more airtime. Over to you, Dr. BHERO.
Okay, thank you, Chair. Yes, let me start by commenting on the first comment that yes, in the R&D department, yes, companies do take advantage of inventors because they get involved in development of products and systems, and then at the end of the day, the company simply takes the ownership, as it were. But if you look at, for example, the South African Patent Act, it's very explicit, about the involvement of an inventor, and that if an inventor is to assign, that invention, it has to be properly done. And properly done, it means the legal requirements will need to be followed. So my recommendation in this regard is that please, fellow technical people, fellow engineers, as the case might be wary of what your contracts of employment are saying. And in this particular space of patents and the like, it might be a good idea to consult a colleague who has some understanding of this, to say, please just look at my contract, etc. Is it favorable? It's not favorable. And then they can advise you, and you can then approach, of course, your employer to say, but look, it feels like, this term in our contract is not consistent with what our laws say, as it were. Then you might have, a redress. But what has been said, yes, it happens, and it happens. And then the second point was that the request was for demystification of patents and the registration of IP. All right. I think the starting point is that I must say IP is the umbrella term that we use, which is IP simply stands for intellectual property. If you like, you call it intellectual property law. That's the umbrella term. Now, below that umbrella, you have different types of protection. For example, you can have what is called copyright protection. That means it's something that falls under the umbrella of IP. Then you might also have what is called, trademarks, protection. It's another type of, protection, IP protection. Then you might also have what is called the plant breeder's rights. It's another type of protection. Then you have what is called the design patent. The example of the design patent that I have talked about, it also falls under the umbrella of the IP. And then you have the pure patent, which I've been explaining. It also falls under that umbrella. So right at the top, you have, IP. Now, all at the bottom, you have different, protections as it were. Now, in our discussion today, we focus mostly on patent because patents are much closer to the work which is done by technical people, be it in academia and engineers in the field as it were. Most of our work is closely related to patenting. So this discussion was just meant to actually expand on patenting, but otherwise patents are part of IP, Thank you.
Thank you, Dr. BHERO. It's quite interesting. Your presentation was well received, and I've got two more questions. I think the other ones are more comments, and we can note the comments. Yeah, there's one question that says, are there any free patent search engines for patents that apply in South Africa? I think that's the first question there from Pashan. And then there's another one. I think the next one is a comment from Peter, and who really says, thank you for your presentation, Peter from Kenya. There's another question here. I think this one sounds like there's a project already from Pascal. It says, suppose you develop a novel commercial product, but it's based on refining a number of existing products to create or package your new offering. Do you then own or owe royalties, to the individual patents? Example, developing a wearable health monitoring device using GPS, cellular modem and SIM cards to develop a miniature product that can be worn by kids, so parents may track their local location and health measurements. I think that's the question there, yeah, from Pascal. Yeah, I think these were the questions, the last two questions, Dr. BHERO. And then the last one, I think it's also Wandile saying thank you for your presentation.
Okay. All right. Thank you, Chair, once more. All right. The first question pertains to patent search. Well, off the cuff, I'm unable to actually give a list, but what I can recommend is that in South Africa, if you check the patent journal, which is published, it should be CIPC, as it were. I'm saying this under correction, because it offers the published patents year after year, and in a year, maybe a number of them, as it were. I would really recommend that please just check with that website. You are likely to find something, but also Google search. I've often found that it gives you a number of patents if you really search with the right information, as it were. But otherwise, beyond this comment, I think I'm unable to give concrete answer off the cuff on the question of the search, And then there was the comment from Peter from Kenya. All right, thank you, Peter. I've noted your attendance. Thank you very much also for attending. And then there was also a comment from Wandile. I've also noted, your attendance, Wandile. And then the question was on commercial products, where a number of existing protected products are put together to make up a new product, as it were. And the question there, if I heard it correctly, was whether this person who has combined different, subjects of patents to come up with a new product owes royalties to the owners of those patents. Now, as long as those patents are still in effect, that means before the expiration of 20 years, if you use anything that uses or that applies one of the claims, at least any one of the claims, in that case, if you do so without the permission of the owner of the patent, you'll be infringing it. So what you will then need to do is to actually get a license from the owner of the different patents that you are using. And you will explain to them, of course, after consulting with an expert, to say to what extent are you using their patent, and that will also lead to the negotiation of how much of that license fee you need to pay to them. So yeah, in short, patented products, if you combine them to come up with something else, yes, you have to actually pay some royalties, to the owners. But let me put a rider to this. I put a rider to this by saying, also remember in my presentation that I said patents are territorial. For instance, if there is a US patent and I get hold of it here, and I notice that that patent has not been applied in South Africa, there's no patent granted for the same product there here in South Africa, I can be naughty and actually start manufacturing it in South Africa. The owner of the patent in US, UK, Spain, you name it, before they can actually sue you, etc., usually, and I say usually, they first of all have to then apply that same patent is granted to them in South Africa, and then after it is granted, that's when they will sue the person, as it were. But like what Neil deGrasse told us, you remember that comment that one needs to really know that one is doing the right thing. You need to have as much information, because if you make a decision based on limited information, you might think you are right, only to realize that you didn't know enough to know that you are wrong, as it were. So I think that would be my comment. Thank you.
Thank you, Dr. BHERO. Yeah, thank you for your detailed comments as well. There's a last one. Sorry, I said there's a last comment. I see there's another one, and it ties in with the previous comment that you've just shared. How do you resolve patent replication between countries without a patent treaty? And I think that's the last question from Tom.
Chair, maybe just to repeat that. I think I missed the one or two words there.
Yeah, it says, how do you resolve patent replication between countries without a patent treaty?
Okay, all right, thank you. I'll start by giving a flat answer here and say this. Since we said patents are territorial, it simply means that, and I will expand on this, it simply means that if one has a patent in South Africa, but that patent has not been granted in Lesotho, someone in Lesotho can actually start making the product of that patent. In Lesotho, there's nothing that can be done to that person because there's no patent, granted there. Now, the owner of the South African patent, if they want to then benefit somehow from the infringement in Lesotho, they will have to then follow a step where they will have to then apply, to Lesotho to have the same patent granted. There is usually what they call priority date and whatnot, but I do not wish to go into the nitty-gritties of that. Only after the patent has been granted in Lesotho, then one can then go and sue the person who was infringing one's patent. And then, of course, where necessary, the court will order an inquiry to be made to assess the damage that you suffered because of that because of that person's infringement. However, I must say also, in terms of conventions, there are different conventions. Some of the conventions are such that if you have a certain group of countries, and if you apply for a patent through their chosen offices, once that patent is granted, it then applies automatically to all members of that particular treaty. But we also have other treaties where it doesn't work that way. What simply happens is that, for instance, the PCT, Patent Cooperation Treaty, doesn't really work in the way that I've mentioned. But the way it works is that when one applies for a patent in South Africa, then goes on to apply to the PCT, the advantage that I get is that the so-called the priority date, that means the date on which I first of all submitted my application, for a patent, it is the date that will be recorded. Then I will apply via the PCT. It goes through different stages. Then when it reaches the final stage, the last stage that follows, they call it the country designation. That means it is a stage where that patent, which has been analyzed at PCT level, now you have to apply to specific member states of each of the countries forming PCT. But the advantage is that as you apply in different member states, it means you'll be able to sue all those people who started infringing your product, provided they started infringing it at a date after your own priority date, as the case might be. So different conventions, that's how they work. But like here, I hope my comment will not mislead some people, but with the little time available and the little explanation I can give for now, that's what I can say for now. Thank you.
Thank you, Dr. BHERO. I must agree with you. With the comments coming from the audience, or question from the audience, that your information is well received, and I can still see questions coming up on the dashboard. And unfortunately, we've got to at some point close the webinar, and otherwise we'll go forever. And it's clear that we might need a follow-up presentation in the near future based on the interest that came from the audience. And it also benefits us as engineers to have you wearing both caps, because your explanation is not just from the law side, but it has got the engineering flavor. I think that what makes these discussions to be more interesting. And the two questions that came in there, maybe if it's possible, I know if we've got an option to answer, we can provide the answer online, and maybe it can benefit everyone. And then it came from Odysseus. He wanted to know how to patent help us invent the future from an engineering perspective while avoiding monopoly. There's another one. Okay, this one is more a comment. A great
Chair, may I ask you to repeat that question, the first question?
Oh, sorry. Yeah, the question was how do patents help us invent the future from an engineering perspective while avoiding monopoly. Yeah, I see time might be against us, and I'm happy if it's fine with you to even drop the comment, your comment on the chat board. Chat box. There's another one saying thank you for the presentation, and please include IP laws on the follow-up webinar. So already I can see that you invited to provide a follow-up webinar. It's a comment coming from Walter. I don't know, maybe last 30 seconds, Dr. BHERO, do you want to provide a quick response to the previous one regarding avoiding monopoly? Yeah, it's a question from Odysseus.
Thank you, Chair. Yes, I think on the monopoly side, it's a tricky one, but this is what I think, though. The monopoly usually is people with a lot of financial muscle. When they are suing you, they can even hire 10 lawyers to work on a case against you, as it were. But now, given a situation, if what we are proposing here works out and gains momentum, that more and more people study patents and be able to navigate around, existing patents and produce their own legally acceptable variants of existing patents. Well, one time or another, they might infringe one way or the other. But what will naturally happen out of this is that you then have a bigger number of people who are actually working on products that may touch or may likely the aspect of patented products. So these big companies with a lot of money and threatening the small people, they will at one point now be flooded with so many battles to fight. So at the end of the day, it might clip their feathers, against monopoly. That's one way, of looking at it. Yeah, but detailed answer maybe we'll provide it, via the chat board. Thank you.
Thank you so much, Dr. BHERO, and thank you to all participants, and thank you for sparing us this time, especially your presentation. As we've indicated, Dr. BHERO, it was well prepared and well packed, and it had both the law background as well as the technical information that we need as engineers. And I'm sure if there's further questions, we'll share these questions with you, and we can provide a detailed response as you've indicated. Some members, I see they already requesting a follow-up presentation, but surely via the SAIEE platform would provide more details when there's a future presentation that is a follow-up from this one. But once again, I would like to thank everyone that has connected this afternoon. And as the KZN SAIEE, we really appreciate your commitment and your interest in this topic. I think it has benefited all of us and all regions that are connected. I know we've got members connected from all provinces. Thank you to all for your connection. And I would like to now hand over back to Ms. Afrobos, and thank you again to you, Ms. Afrobos, for your support as well. back to you, Madam. Thank you.
Thank you, Shepherd, and thank you, Dr. BHERO, for joining us in this very informative webinar. I do see that there should be a follow-up on this, seeing that there's a high interest. And just for Dr. BHERO and the attendees' information, I'm busy working on the August issue of the What Now magazine, which features manufacturing. And I do believe that the patent law and IP information should actually be an article in this issue. But I will email Dr. BHERO afterwards. But thank you very much for joining us. And please look in the chat box. I have included the link to the patent journal for you to just quickly copy and paste and put it in your browser. That takes you to the SIPSI site. They'll give you more information on that. Alternatively, if there's any additional questions you need to ask, you're welcome to email the KZN Centre directly, kznc@saiee.org.za, or you can email myself, Minx, M-I-N-X, at saiee.org.za for any questions, and I'll forward that to Dr. BHERO or Shepherd. Anyway, have a lovely evening, ladies and gentlemen. Stay warm, stay safe. Until next time. Goodbye.
Okay, thank you. Bye-bye.
Thank you.